In this talk, we're going to deal with the separation of church and state as it relates to the Constitution of the United States, in particular the First Amendment. And let me recite the First Amendment to you, at least the part that deals with the supposed separation between church and state. And we're going to come back to this on a fairly regular basis. That Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, again, you'll notice in the First Amendment that there is no mention of the separation between church and state, and we'll talk about that in a moment. But many modern civil government theorists contend that they rule at no one's discretion, that civil government in and of itself is an entity unto itself. There's no authority over it, not even the people in many respects. We especially see this in communist regimes and totalitarian regimes. Here in the United States, of course, we do have the principle of we the people, but oftentimes when people get into political power, they even dismiss the idea that the people have any say in anything. And they especially don't like the idea that God would be over them in some sort of a sovereign capacity. And in a 1982 message, Francis Schaeffer made the following point. We must understand something very thoroughly. If the state gives the rights, it can take them away. They're not inalienable. If the states give the rights, they can change them and manipulate them. But this was not the view of the founding fathers of this country. They believed, although not all of them were individual Christians, that there was a creator and that this creator gave the inalienable rights, this upon which our country was founded and which has given us the freedoms that we still have, even the freedoms which are being used now to destroy these freedoms. And Schaeffer saw something in 1982 that is coming to bear in our own day at a rapid pace. And let me give you an example. Recently, there was a school teacher out in California. For 17 years, he had posted very specific references from America's historical past. In his classroom, there was a group of slogans that he had up that were in operation for 17 years, or another group that were up there for 25 years. In 2007, the principal of this school decided that all of these had to go. And let me give you some of what they were. The teacher's name is Bradley Johnson, and he had things like, "In God we trust," "All men are created equal," "They are endowed by their Creator," and a couple of other ones. The ones he had up there for 25 years contained the words, "In God we trust," "One nation under God," "God bless America," and "God shed His grace on thee." And the principal said these had to go because it was a violation of the Constitution, in particular the separation of church and state doctrine. Since these are religious phrases, they cannot be put in a public school. Well, if you know anything about these particular phrases, they have some sort of historical precedent in America itself. For example, "In God We Trust" is America's motto. It's on all of our coinage. That we are endowed by our Creator with certain inalienable rights comes out of the Declaration of Independence, which is again another official United States document. It should be taught in public schools across the country. "One nation under God" was added to the Pledge of Allegiance in 1954. Students on a regular basis in public schools get up and pledge allegiance to the flag with that particular phraseology in it. "God Bless America" is a patriotic song that was originally penned by Irving Berlin in 1918 and then came back out again 1938 with a few words changed. And you may remember this particular stanza. I promise I won't sing it for you. There's a very wonderful rendition of "God Bless America" by Kate Smith. "God bless America, land that I love, stand beside her and guide her through the night with a light from above. From the mountains to the prairies to the oceans white with foam, God bless America, my home, sweet home." "God shed His grace on thee" was another slogan that this particular teacher put up, and it's a line from the patriotic song "America the Beautiful." In all of these examples, you will find that they form the warp and woof of American culture and society and official documents in our nation. And yet the principal of this school maintained that just to hang them in the public school classroom was a violation of the separation between church and state, and more specifically to the Constitution of the United States, the First Amendment to that Constitution, which outlawed such practices. So what was the outcome of this? Well, a brave and, I have to say, educated judge, Judge Roger Benitez, objected using historical, legal, and logical arguments, the very things that you would think would take place in a public school classroom. And what the principal wanted to do is essentially do something like 1984, and that is to wipe history clean, to throw down the historical factuality of America's founding down the memory hole, using the Constitution of the United States to do that. So he wanted to take one aspect of history, use it in his favor, deny other aspects of history in order to make his case, the whole time muddling what the First Amendment is all about. And here's what the judge said. May a school district censor a high school teacher's expression because it refers to Judeo-Christian views, while allowing other teachers to express views on a number of controversial subjects, including religion and anti-religion? On undisputed evidence, this court holds that it may not. It is a matter of historical fact that our institutions and government actors have in past and present times given place to a supreme God. We are a religious people whose institutions presuppose a supreme being. As the Supreme Court has acknowledged, there is an unbroken history of official acknowledgement by all three branches of government of the role of religion in American life from at least 1789. So, when you look at the historical record, as Judge Benitez did, he says, you are denying the historical record on all of this. So how is it possible that a school classroom can deny this history and then use the very historical document which defends the posting of this history, the Constitution of the United States? And this is what this principal wanted to do. Judge Benitez went on to say, fostering diversity, however, does not mean bleaching out historical religious expression or mainstream morality. By squelching only Johnson's patriotic and religious classroom banners while permitting other diverse religious and anti-religious classroom displays, the school district does a disservice to the students of Westview High School, and the federal and state constitutions do not permit this one-sided censorship. And this is really what you have to do in order to reread the Constitution, is you have to wipe the slate clean of America's historical founding, which this particular principal wanted to do. And of course, if you do that, young men and women going into the public school system get no idea of America's historical founding, and so they're easily manipulated by whoever is in office at that time. So this was an arbitrary edict in order to promote a particular view of reality. Now, our founders feared this type of draconian action by civil officials. And so while the Constitution of the United States was signed September 87, drafted in September 87, and then sent to the states, when it finally got to the states said, we're not satisfied. Even though the federal Constitution is a document of enumerated powers, we want further restrictions on the federal government. We want specifics in that Constitution to say, you don't have this power. Even though the Constitution of the United States, again, was a document of enumerated powers, which a number of the founders, a number of the Federalists pointed out, John Jay, Alexander Hamilton were two of them, who said, look, we really don't need a Bill of Rights because the Constitution is not a document of a declaration of rights. It's simply a document that states what the powers are that the government has. And if those powers aren't, in fact, listed, then the federal government does not have that power. Here's what Alexander Hamilton, one of the authors of the Federalist Papers, had to say. He says, "For why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions may be imposed? He was saying simply this: look, why tell a government what it can't do when the purpose of this particular document is only to list the powers that the government does have? So he said to actually put into the Constitution a statement about what the government cannot do really nullifies what that document is all about. Modern-day constitutional scholars follow the reasoning of people like John Jay and Alexander Hamilton, and making the same point. James McClellan writes this: the U.S. Constitution was premised on the seemingly unassailable assumption that the rights and liberties of the people would be protected because the powers of government were limited, and that a separate declaration of rights would therefore be an unnecessary and superfluous statement of an obvious truth. Since the government of the United States was to be one of enumerated powers, it was not thought necessary by the Philadelphia delegates to include a Bill of Rights among the provisions of the Constitution. But the Anti-Federalists still insisted, we want further restrictions on the federal government, and the Anti-Federalists won. It went back to the states. The states insisted on a Bill of Rights. The First Amendment is the First Amendment in that Bill of Rights, and that's why we have it today, because the Anti-Federalists insisted on it. And why is that? Because most of our founders, I would say all of our founders, had an innate and historical suspicion of centralized civil government. And without further restrictions on basic individual rights, they feared that the federal government could exercise powers not granted to it because they were not prohibited by the Constitution. So they reasoned this way: yes, we understand the document is a document of enumerated powers. We understand that. But we also understand the nature of man. We understand the nature of power. When you put man and power together, they can do anything they want with the Constitution. And we're beginning to see that take place. Their attitude was better safe than sorry. And they reasoned that a formal declaration of rights was essential to secure certain liberties. And that's exactly what they did. And that's how we got the Bill of Rights. That's why we have the First Amendment, because the First Amendment was designed to keep further restrictions on the federal government. So in winning this particular argument, now we have to deal with the context of what is the First Amendment, what does it mean? In any piece of literature that you find, even when you interpret the Bible, the first thing you have to do is deal with what does it say, before you can get to the next point of saying what does it mean, and then finally to get to how does it apply. So what does it say, what does it mean, how does it apply? And unfortunately, on the First Amendment, we have this idea that the First Amendment deals with a separation between church and state. Now, it may, but the first thing we have to do is declare what does it actually say. And as I mentioned to you, it's very clear. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the language of it all. And there are a couple of things you need to note. There is no mention of the words church, state, or separation in the First Amendment. Those words do not appear, because the argument back then was not over the jurisdictional separation between church and state. That was already settled. The issue was what would be the relationship between the national government and the state governments. That's why the First Amendment begins with Congress. Congress shall make no law. Included in the amendment are additional rights which relate to the free exercise of religion. The right to talk about religion, freedom of speech. The right to publish religious works, freedom of the press. The right of people to worship publicly, either individually or in groups, freedom of assembly. And the right to petition the government when it goes beyond its enumerated powers. The right of political involvement. All of those freedoms are compacted in that First Amendment. So the one dealing with religious freedom is also coupled with the freedom of speech, the freedom of assembly, and so forth. And the reason for that is because they go together. It's not that Christians just get to go to their church on Sunday and live within the confines of those four walls, but they have the same freedoms as anybody else has regarding speech or assembly or with writing, freedom of the press. The prohibition in the First Amendment is addressed exclusively to Congress. Individuals and governmental institutions are not included in the amendment's prohibition. As clear as this is, some try to rewrite the First Amendment in order to fit their misconceptions about its meaning and implementation. And so, while the First Amendment says Congress shall make no law, what some want to say is, well, this applies to schools and it applies to courthouses and so forth. It does not. It's very specific. Congress shall make no law. And so if a young man or a young woman wants to get up and talk about how God has affected them as they went through school in their valedictorian address, First Amendment doesn't apply there because Congress isn't making this particular law. This is an individual student making this declaration. And if the state, if a state wants to make this declaration, it can do so. If a state wants to prohibit these types of things, then it needs to write it into its own Constitution, because the First Amendment to the Constitution does not apply to the states, although some have done this through the 14th Amendment, but that's another question for another day. There is no mention of a freedom from religion. The First Amendment offers no support of a position that would outlaw religion just because it exists and offends certain people. People will say, I'm offended by this religious mention or this religious declaration. I'm sorry, the Constitution does not deal with things that personally offend other people. We're dealing here with historical realities. There is a second part to the religion clause of the First Amendment that states that Congress cannot prohibit the free exercise thereof. So this is a twofold freedom. Congress shall make no law respecting an establishment of religion, and it cannot prohibit the free exercise thereof. And generally what happens in these court cases is you'll find the courts ruling Congress shall make no law respecting an establishment of religion, but it doesn't deal with the idea of this expression of religious freedom. So with so much debate, how does anyone know what the First Amendment really means? Well, this again is true of any particular literature. You've got to go back to the original sources of that particular period. Here's what Thomas Jefferson said in understanding the original meaning of the First Amendment, or anything relating to history. The same thing with the Bible. On every question of construction, carry ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed. So if you want to know what the First Amendment means, first, know exactly what it says, and second is to go back and look at the people who actually drafted it in their particular documents, and then understand the context of the time, and then follow their particular examples on what they did. Here you have in the Constitution itself, it says this was done in the year of our Lord, 1787, sets Sunday aside as a day of rest, days of prayer and thanksgiving. Presidents of the United States took the oath of office with their hands on an open Bible, etc., etc., etc. There were declarations of national days of prayer and thanksgiving. There were chaplains who were paid for in order to service Congress. Well, you look at the context of this period, and apparently that was not a violation of the First Amendment. James Wilson reiterates this idea. He was one of only 6 men who signed both the Declaration of Independence and the Constitution, and who also served on the Supreme Court, so he should at least have some knowledge of what was going on here. And he again goes along with what Jefferson said: the first and governing maxim in the interpretation of a statute is to discover the meaning of those who made it. So you have to go back and look at those people who actually drafted this. A little bit about the amendment's history is important as well. As I mentioned to you, that when the Constitution was sent to the states, a lot of the states already had their own religious provisions in their particular state constitutions. And they wanted those protected, and they didn't want someone coming along, especially the federal government, saying you can and cannot do this. So it was once again sent back so that the Constitution would impart in there, essentially saying, hands off the states. Congress shall make no law, has nothing to do with the individual states. Now, the phrase, well, let's go a little forward here and to get some idea of another Supreme Court justice, Justice Joseph Story, to give his impression of what this was all about in the First Amendment. And here is his interpretation of the First Amendment. Now, he is a 19th century Supreme Court justice, not that far removed from that particular period of time. He says the real object of the First Amendment was not to countenance, much less to advance Islam or Judaism or infidelity by prostrating Christianity, that is, by making all these religions equal, but to exclude all rivalry among Christian denominations and to prevent any national ecclesiastical establishment which would give to an hierarchy the exclusive patronage of the national government. So what Story is saying here, look, it was designed to keep a rivalry from taking place among the Christian denominations, which were already existence in the colonies. It wasn't to bring all religions down and make Christianity equal with them. It was to keep a rivalry out from under Christianity, which in fact the states understood. He makes, and this assessment presupposes that Christianity was the accepted religion of the colonies, but that no single sect, that's what they used as a word for what we use today as a denomination, was to be mandated by law. The amendment was to keep Congress from interfering with the business of the states. Now, the phrase itself, the separation of church and state language, we oftentimes think that it was a part of Thomas Jefferson, that Thomas Jefferson had written a letter to the Danbury Baptists in 1802 dealing with his opinions about the First Amendment. And a couple of things here. First off, he was not the first person to use the phrase separation between church and state. And secondly, Thomas Jefferson didn't have anything to do with the drafting of the First Amendment. He wasn't there at the drafting of the Constitution even. And a third thing to keep in mind is, since when is a letter by a president all of a sudden trump law, constitutional law? Presidents have written letters on all types of things. I mean, there are volumes and volumes and volumes in publication today just on the letters of the presidents. So why is it that the courts just pulled out a letter from 1802 and used it as substitute language for the First Amendment? If we can do that with one president and one letter, then why can't we do that with all of the presidents and all the letters? So it's a little bit of judicial shenanigans here. But the phrase itself, separation between church and state, goes back at least as far as Martin Luther. He wrote of a paper wall between the spiritual estate and the temporal state. In his Institutes of the Christian Religion, John Calvin asserted that the spiritual kingdom and the political kingdom must always be considered separately because there is a great difference in unlikeness between ecclesiastical and civil power, and it would be unwise to mingle these two, which have a completely different nature. And see, this was not a debate over that. Because what was happening here, they understood that the ecclesiastical realm and the political realm were different. They operated in different ways. One was over civil matters, the other one was over church or ecclesiastical matters. One used the power of the sword, the state. One used the power of the keys, the church. The church was limited in its jurisdictional authority, very much like the civil magistrate was. Civil magistrate couldn't go into the church and tell the church how to run its affairs and use the power of the sword to impose that on the people. The church could not take its doctrinal absolutes, go to the state, use the power of the state in order to enforce people to go to church on Sunday, to pay a tithe, to get baptized, or whatever the case might be. There was this jurisdictional separation between church and state. Connecticut Anglican divine and theologian Richard Hooker described walls of separation between the church and the Commonwealth in his Of the Laws of Ecclesiastical Polity. Now, the question comes down to, where did Thomas Jefferson get the phrase? Jefferson had a library, a very large library, that he sold to the Library of Congress. And we know that at least one of the books in his library dealt with the separation of church and state idea. We know that Roger Williams used the phrase, Roger Williams from Rhode Island. The history of this does not rest on Thomas Jefferson. But what did Thomas Jefferson actually write in his letter? This is what he said. believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for faith or his worship, that the legislative powers of government reach actions only and not opinions, I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. So in that particular phraseology, we find from Thomas Jefferson that separating from church and state is of two natures. The state can't come in, use the power of the sword, and impose particular religious views on people. At the same time, we know that the purpose of it is to keep the states free from the federal government, which was something Jefferson was all about. So Jefferson actually supports the biblical doctrine, but what's happened is that the courts have turned around, taken Thomas Jefferson's phrase, used it as substitute language for the wording of the First Amendment, and then interpreted that language the way that they want to do, which means to keep religion out of civil affairs altogether, so that if an individual says this is wrong because the Bible says it's wrong, therefore the civil magistrate can't be involved in it at all. This does not support the biblical idea of the proper relationship between church and state, and it certainly doesn't support the constitutional view. Now, so while Jefferson used the phrase in his letter to the Danbury Baptist Association, and consider this, 1802, that particular letter is drafted, but it doesn't appear in a court case until 1947. So from 1802 to 1947, no one ever thought to look at what Jefferson had to say about this. So this 1947 reference by when Justice Hugo Black used it in Everson versus Board of Education is the first time it's used. So there wasn't even any precedent prior to 1947. And when Jefferson was in Virginia, remember what we're doing. We're going back here, looking at what it said, what it meant, and then looking at the context of the time, go all the way back and see what those people actually did. Well, when Jefferson issued proclamations declaring days of public and solemn thanksgiving and prayer to Almighty God when he was governor of Virginia. Jefferson's Virginia bill for punishing disturbers of religious worship and Sabbath breakers. I mean, can you imagine that? It was introduced by James Madison in the Virginia Assembly in 1785, just 2 years before the drafting of the Constitution and just 4 years before the drafting of the First Amendment. And that particular law became a law in 1786. And you will see on the book that is supplied with this PDF version of this book, what that statute had to say. So Madison and Jefferson were not opposed at the state level for making these religious declarations, and again, that was the very purpose of the First Amendment. Congress shall make no law. Let the states decide what they want to do on religious issues themselves. If they want to build additional freedoms and prohibitions into the First Amendment, they can do that on their own. As president, Jefferson included a prayer in each of his 2 inaugural addresses. He signed bills appropriating money for chaplains to Congress and the armed forces, and signed the Articles of War, which not only provided for chaplains, but also earnestly recommended to all officers and soldiers diligently to attend divine services. Jefferson advocated the tax-supported College of William and Mary to maintain a perpetual mission among the Indian tribes, which included the instruction of the principles of Christianity. And you can go on and on with the history of all of this, and that's what Judge Benitez did. It says when you go back and you look at the history of all of this, the First Amendment is very clear. It's designed to prohibit Congress from interfering with the rights and regulations and jurisdictions of the church, of the states. It was to allow the states to do what they wanted regarding religion. It was the denial of the federal government's authority and power over the individual states. According to Jefferson, the federal government has no jurisdiction over churches or state governments. Many contemporary writers attempt to read back into the past a wall of separation between church and state, which in fact never has existed in the United States. So when you look at the history, study the context, go back and see what our framers actually did, look at the original documents, we can come down on no other side than this, that the First Amendment is designed to keep Congress out of the business of the states. The states are empowered to do what they will regarding religion, and the way that we can maintain all of this is that we as Christians continually get involved to show that God's Word applies to every area of life, not just in family government and church government, but also in civil government.